Thank you for tuning in to this episode of the More Right Rudder podcast, the podcast for flight instructors on the go. I'm Sarah Stout, the Program Development Manager here at NAFI, and your host for this podcast. Before the episode, we'd like to take a moment to thank the sponsor of today's episode, AOPA. Take a few minutes to check out their website and see all that they do for general aviation and all of their membership options. Their website is aopa.org, and we'll have a link in the show notes as well. Today, we are joined by Anthony Ison of the Ison Law Firm in Lakeland, Florida, where he specializes in airman medical certification. Anthony was born and raised in Lakeland, where he was never far from aviation. He became a licensed pilot at the age of 17 and has been involved in aviation ever since. You may already know him from the Pilot Lawyer podcast, where he and his firm discuss FAA medical certification from a legal perspective. Welcome, Anthony. Thanks so much for joining us today.
Hey, thanks, Sarah, for having me. It's a pleasure to be here, and thank you for putting this show on. It's great. I love listening myself, and I also love your variety, the episodes you produce. So thank you very much.
Oh, thank you. That's good to hear, as I'm still getting my feet wet, so to speak, on this. So today we're here to talk about CFIs helping out and what they need to know with their customers and for themselves for medical certification.
Sure, Sarah. Yeah, and I think it's a great topic to discuss. Personally, I think it's a good topic to discuss because that's what we do in our practice. But before we start, I just want to kind of give a caveat, disclaimer to everybody that my appearance here is not, and anything you hear from me is not medical or legal advice that you should take to the bank. You should definitely consult with your doctor for medical purposes or a lawyer for legal purposes. And beyond that, it's not legal advice that NAFI is providing. So now that I've made the obvious lawyer comments, we can kind of get into it.
All right, great. Always got to get that out of the way. So our first thing we wanted to talk about is how flight instructors really are pretty frequently the first touch point a prospective pilot will have in aviation. A lot of pilots or prospective pilots come to the airport not having any idea what they need or do. And CFIs want to provide good customer service to help those people along the way, but they need to know kind of where those limits are. Of course, as CFIs, we want to encourage our prospective pilots and customers to get their medical applications in and try to get that process going early in the training. So as flight instructors, when we're talking to pilots about this, what should we know or what should we be aware of from the legal perspective?
Sure. Great question, Sarah. So there are many avenues that we could look at as far as liability for the flight instructor and so on and so forth, whether it's like a tortious or personal injury type issue where, hey, I'm going to sue the flight instructor for things that they didn't tell me to do or things that they did tell me to do, that type of thing. We're not really looking at that here today. That's not really what our firm does. Instead, more so the liability or potential, I don't think it's liability, it's just, sort of the goodwill towards the customer as a flight instructor, as to how that introduction to the medical certification process should go. So we've seen cases where, unfortunately, certified flight instructors have instructed their students in a way, or their customers in a way that has unfortunately led them to a point that has ended in their certificates, either their medical certificate or their student pilot certificate, or even unfortunately subsequent ratings having been revoked for how the flight instructor had instructed the student to conduct the medical certification process. So I'll sort of give you an example on that sort of thought process there, that on the medical application, of course, it's a federal form. And the FAA takes that form very seriously, and that their perspective is if you don't provide appropriate answers on the medical application and the FAA finds out about it, they can find out about incorrect or inappropriate answers, if you will, or omissions from the application. They can pursue an enforcement action against the airman, the applicant for the medical certificate, wherein they would revoke not only the airman's medical certificate, but also the ratings that they may hold, whether it's a student pilot certificate, private pilot certificate, or whatever you may have. We've seen it with ATP certificate holders. And so you don't want your student or anybody to be caught up in that predicament, in that it's a fairly difficult defense of an airman who maybe hasn't reported their medical history appropriately and should have, and the FAA is pursuing an enforcement action. And so we have seen cases before where CFIs have instructed their students in a way that may have unfortunately influenced an incorrect answer. More specifically, we've seen cases where CFIs have actually completed the 8500 for the student. We've seen cases, the student is essentially sitting across from the CFI, and the CFI is filling out the 8500-8, the MedExpress form, and just asking the student questions, and unfortunately paraphrasing the actual questions that are on the medical application, which isn't good because they're very specific questions on the medical application. If, as I'm sure your listeners are aware, it's a poorly worded application, to be honest with you. Congress has done a study on some of the questions through the GAO. There's one question, 18B, which is the DUI question, and GAO's identified that you'd have to have 23 years of education to actually understand what that question is asking of you, which is crazy. I mean, not, I don't say this braggadociously, but I've been to law school, and I don't have 23 years of education. So the vast majority of individuals, unless they're PhD and master's holders, it's a difficult question to comprehend unless you are thinking about it. And so we'll see cases, and we've seen cases where the flight instructor will say, hey, do you have a DUI? They get to that question, they'll try to say, do you have a DUI? And the student will say, well, no, I don't have a DUI. But really, maybe they were arrested for DUI, which is what the question looks to elicit. But it was dropped down to a reckless driving charge or a conviction, or maybe it was dismissed altogether. So the perception of the student sitting across the desk is that, oh yeah, I don't have a DUI, so I told him I don't have a DUI. And so the CFI says, great, I'll say no to this, and the application is submitted. And then ultimately, especially with the DUI type question, the FAA has access to that information, to the NDR, the National Driving Register, and it results in the FAA saying, well, this is inconsistent. This applicant indicated no DUI, but we have evidence of an arrest for a DUI, for example, which is one of the things that the question asks, if you read it specifically. And then an investigation is initiated by the FAA, which can result in, and most of the time, unfortunately, does result in the airman losing his or her student pilot certificate or whatever certificate they may have, unless there's a defense that can be made. And in this type of case, we would see a situation where maybe the CFI would be brought in as a witness, and potentially even kind of thrown under the bus, unfortunately, as sort of what we would call a reasonable reliance argument, where the student would have to sort of go against the CFI and say, hey, listen, the CFI filled this out for me. I was just a student. I just showed up and he said, ask me these questions, or that's unfortunately how that unfolds. And so it's just a rough position for the CFI to be in. And depending on how feisty of a person you have in that situation, are they going to try to pursue an action against you, individually? It's hard to say, and I can't speak to that because that brings in state law issues, but it is something that definitely the CFI should consider, not producing the results, or excuse me, producing the answers to the 8500 on behalf of their students or their customers, but instead, I think, giving good guidance as to what is expected by the FAA on these applications, which to some people's surprise is everything. The question on the question 18 on the medical application asks for, in your lifetime, have you ever been diagnosed with, ever had, or do you presently have, any diagnosis? And question 18X is a catch-all, asks for essentially all illnesses, disabilities, or surgery. So the onus sort of on the airmen to represent their entire history. And I think if the CFI were to make that clear to the customer, the student, at the initiation of their sort of aviation career, if you will, that's important because it can really help focus how important that application is moving forward throughout their career.
Right, because I've
So, sorry
personally,
for the long answer.
it's all right. Because I've personally worked with new students and rusty pilots and that who've said, oh well, I had such and such medical event, but it was 20 years ago, 30 years ago. That can't possibly matter. I'm like, yeah, it
Sure.
does.
Yeah,
And some
it does.
things, even in the most recent like doctor's visits, I've had people say, well, I don't have to put that down. It was just an urgent care for a sinus infection. It's not a big deal. Well, it still happened in in
Sure.
that period. So,
That's a,
um,
yeah, yeah. We've seen cases where individuals have lost significant certificate. I mean, they lost ATP certificates, type ratings. I mean, precious type ratings that they have lost because the FAA has found out about conditions from 20, 30 years ago, or DUIs that they thought were, and this is a pretty common issue, DUIs they thought were expunged or sealed from decades previous. We've seen cases from where individuals have had arrests for DUIs dating back to the 80s that the FAA will spontaneously find, and then you're a captain at a legacy air carrier, and next thing you know, you're not, unfortunately, because of how the FAA will pursue these pretty aggressively.
right. So then the bigger picture then for CFIs would be, if you're helping your people through these medical applications, really your best course of action would be to encourage honesty and completeness more so than guidance on any particular issue. And also,
Right.
as a CFI, you're also a lot of times someone, this applicant just met. So to be assuming that, this person is even comfortable disclosing their entire medical history to you while you were going to sit across the table and tick some boxes,
Sure.
is something as well.
That's a
There's medical privacy is also a significant concern.
That's a very good point. Yep, and being a lawyer, and we have attorney-client privilege with the individuals that we come in contact with, and we're discussing their medical history with them. And I can tell you that unfortunately, we don't get the full story. So I think it's unlikely that the customers or the students are going to feel comfortable or even really divulge that entire history. Because to be honest with you, I don't go to the doctor that much, as you can probably tell by looking at me. But it's a situation where most people don't even know what their diagnosis is or their
Mm-hmm.
medical history is. I mean, as ridiculous as that sounds, we'll have situations where we'll get the medical records for a client, and they'll have medical history diagnoses that were included in their medical records that they had no idea so that even existed or was recorded in their medical records. So a lot of the times we will encourage people to contact us to obtain their medical records even before they complete their 8500-8, their MedExpress,
Mm.
because it's that important to make sure that if, for example, you report on your medical application you have a history of diabetes, and the FAA asks for your medical records, and come to find out you have not only diabetes, but you also have a history of asthma, or you have a history of ADHD, for example, and that's included in those records that go to the FAA, but it wasn't included on your medical application, that can get exposed pretty quickly. So the point being here is that giving some forethought into the application and encouraging customers or students to have that forethought going into the process is important. And not just a situation where they say, hey, come over here, let's quickly fill out your MedExpress or your medical application, but hey, here's the MedExpress. take some time with this, student, and we want you to take this home, fill this out, think through it. And I think that would be something to encourage, sort of more time spent with the application.
And along with that time, we've brought up and you've brought up a couple of conditions. We brought up the DUI, ADHD, diabetes. All of these are kind of some key words that if flight instructors are hearing their customers talk about, simply ticking that box on the form could even still end them up in a situation where they aren't going to get issued in the office. They still need to know more. So it would be good for flight instructors to at least know some keywords of some of those kind of like higher level conditions or situations such as DUI, where they would probably want to tell their customers, hey, the FAA has bigger concerns with these. In my opinion, as a flight instructor, that's where I would say, draw the line and tell them to go talk to a medical certification specialist. It's good to know what those conditions and situations are. I personally wouldn't want to try to talk someone through it, but some of those others, we had mentioned those first three, but there's also depression, cardiac issues, and the most recent one that popped up was the VA disability that popped up and has caused some trouble for airmen. I spoke to one of our members yesterday who's still dealing with that.
Sure. Yeah, unfortunately, a lot of folks are. We're seeing still the VA is an issue that we're working through, but that's a great point. I will give credit to the FAA. Excuse me. I'll give credit to the FAA, and I think people see a lawyer and they think that there's going to be an antagonistic relationship with whomever I come in contact with, which is just not the case. And it's definitely, we try to have a good relationship with the FAA, and so I'll give them credit for the fact that I think they are doing a lot to try and mitigate some of the more archaic thought processes on various conditions, mental health conditions, and so on. That things are really, I think, progressing. Maybe not at light speed, and maybe not the way the general public or the general flying public would like to see per se, but it is improving. So I say all that to say, even with the change, even with the improvements, even with more streamlined process, there are still conditions that will warrant review and preparation by the airman, and then subsequent review and preparation by the FAA before a medical certificate could be or will be issued. And so that includes those types of conditions that you just mentioned, Sarah. So for example, marijuana use, just kind of running through them real quick. Marijuana use, I'm not sure how it is where you are, Sarah, but around here, I just recently learned what marijuana actually smells like. So what does that smell?
Yeah,
And
it became legal in Maryland a year
me.
ago, and like I know a couple houses in my neighborhood that like when I go walk my dog, that like I I avoid. It is like we're if their garage doors open, I know to go the other way.
Yeah, go, right. And so it's a situation where that is becoming a more prevalent, marijuana use is becoming more prevalent substance use. It's no doubt about it across the entire country, I guess the world in some capacities. But that being said, because of the prevalence that we're seeing, more use and more limitations taken off of marijuana use, we're seeing more uses by individuals that may want to get into aviation. And so the problem there with that is that the current posture of the FAA is that marijuana use is essentially defined as to the FAA as misuse of a substance, which then therefore meets criteria for substance abuse if that use has been consumed within the past 2 years and the FAA can establish that. So not to bore you with those details, but it is an important piece to maybe have the CFI sort of reference that or mention that going into like the initial training atmosphere, because if you have somebody that's had been using recreational or medicinal marijuana that wants to start flight training, which maybe is perfectly legal. There was no aspect that seemed that they couldn't do that. There's a disconnect there between the real world, if you will, and how the FAA perceives that use, whether it's legal or not. The FAA at this point in time is still considering that substance abuse and would require the airmen to have to undergo a period of monitoring through with the HIMSS AME. So there are things like that. There are nuances of certain issues and conditions that may be very prevalent that some CFIs should know about to sort of counsel their students or customers on. The same thing with like ADHD. ADHD has really come a long way, if you will, with the FAA, and that they've developed this fast track program to help streamline certain individuals who meet criteria for ADHD. But for the most part, and what we see in our practice, we see ADHD is a pretty common concern for individuals. The ADHD standard track, which is what a lot of folks fall into, requires neuropsychological testing, and which can be a bit arduous and will require a deferral by the AME. And so it's good to know that well in advance of training. And I think it's something that CFI should probably try to bring up, especially with kind of the atmosphere with ADHD. It seems to be a pretty common issue, especially, you know, people that are my age. That was thrown around a lot for school children, and it's kind of starting to catch up with the population that is now interested in flying. And so that will take a good deal of time to process through the FAA. So ADHD is an important one. Depression and anxiety, there's a lot of nuance there. And it's preparation by the airman ahead of the time of an AME examination is important, because the airman may, if appropriately planned, may be able to get through the AME examination with a medical without getting deferred based off of some of the FAA's more recent guidelines. It's an uncomplicated mental health concern. There's a new track for that, if you will. But some cases, depending on the airman's history and their diagnosis and so on, it very well will lead to a deferral and the requirement for production of records and evaluation with a psychiatrist. That's important. Cardiac type concerns, traumatic brain injury, neurological concerns, all of these things, when I think if the CFI were to identify, hey, cardiac, neurological, these types of things are inclined to warrant a deferral by the AME, it would be good to kind of express that early on so that the airman or the student will know, hey, you know, I should probably get my medical before I jump into training, so that I know that this could be, I don't have to stop midway through my training and wait for my medical certificate, which can take, 6, 7, 8, 9 months in some cases.
And a lot of that extra testing you brought up, like the neurological evaluation, perhaps psychiatry, the cardiac, like if you're looking at a stress test, an echo, all those, if you're doing them for the purpose of an FAA medical and not, as part of the course of, your health insurance probably isn't going to pay for that. And those tests in that alone can be pretty pricey. It's much less by the time you're talking the price of, and now what, renting a typical training airplane's 200, 250 wet, an hour, depending on where you live, and throw your CFI on top of that. And so, like you said, getting this stuff out of the way and knowing those couple key words. And I think the big message there is encouraging those applicants, whether they're first time applicants or, rusty pilots who maybe haven't had to apply for a medical in 20 years. And now their medical history is, different than when they were, 20, 30, 40 years old. And knowing to do that homework first. That's one of the biggest things I'll see. I'm in several groups on social media for pilots, and sadly you'll see someone, just go apply. And then we also see a fair number of posts that are like, hey, I got this letter in the mail from the FAA. And well, you're on the hook now. There can be benefits to not applying, especially if you were looking at like gliders, sport pilots, some of those other options where it could actually be to your advantage to never apply for a medical.
Absolutely. Yep. And that kind of leads to a point on basic med, and I'll kind of talk to you about that. I would say, to your point, that it starts at the beginning for the CFI, kind of bringing it back to the application. If you're encouraging the airman or the student to take that time with the application, and they're doing their homework, they're getting their records, it's going to kind of come out early on that, hey, I may have the medical history that needs to be appropriately disclosed. And I think if it kind of all starts with the application, if that makes sense,
Hmm.
and encouraging that thorough look at it. And so right on down from the teenager, like I was when I got my
Hmm.
airman certificate, down to the 60-year-old rusty pilot. Knowing what's in that history and being able to present that appropriately and knowing what's there, so you're not caught off guard. I feel so bad for the folks that have contacted us and they're starting orientation at a aviation college, next month, and they have, a significant history that they didn't realize they needed a medical. It's always frustrating because that's always a time crunch. Usually, most of the time, it's not feasible if they have a fairly significant medical history. So knowing early on is important, but right on down to the rusty pilot, like you had mentioned, we had kind of we've discussed earlier that the VA disability benefits or other conditions that may have developed over time over someone's age. With basic med, it depends on what you want to do, of course. If you're wanting to go, if you're not 65 yet and you're wanting to go fly a 121 carrier, if you still want to do a 135 job, it depends on what you want to do, but if basic med is satisfactory to your desired outcome here, as far as what you're going to fly, where you're going to fly, when you're going to fly, basic med is a great option for a lot of individuals. And I think basic med is not talked about enough. It's not given its due weight. And I have a personal opinion. It's an unpopular opinion, probably, but I don't think the FAA likes basic med, number one. I know that they don't. I know the AMEs don't like basic med. I've never seen an AME that was willing to sign someone's basic med form, if you will. And I think there may be some commercial reasons for that, and they don't make as much money off of that. I just don't think people push basic med enough where it's appropriate. But the reason basic med may be appropriate is it was designed for individuals like the rusty pilot or somebody who's not wanting to go fly a 121 carrier that has held a medical certificate, and their most recent medical certificate was validly issued. They've held a medical certificate since July of 2006. Their last medical certificate wasn't denied, suspended, revoked, and it was validly issued, like I said. If they were on a special issuance, originally their special issuance hasn't been withdrawn, and they don't meet certain criteria in that they don't have more significant, aeromedically significant conditions, which are outlined in the basic med rules, which are in part 68 of the Code of Federal Regulation. And essentially, those conditions are pretty significant. Most individuals, most of the rusty pilots, if you will, if they've had an interim condition, let's say they stopped flying in 2010, if you will, and it's now 2024, and they just say, hey, I want to get back into flying. I did have a medical certificate back in 2010. But in the interim, I've developed a nasty case of obstructive sleep apnea, of asthma. Maybe I had a traumatic brain injury. And so I don't going and getting a new medical is going to be somewhat complicated. It's going to require more legwork. That airman, if they're not wanting to fly commercially, would be very well be eligible for basic, because those conditions I just identified as an example are not listed as disqualifying for basic med in Part 68. Those conditions in Part 68 are like heart replacement, substance dependence, substance abuse, psychosis. So they can be fairly significant medical history. But if you have some of these things that, yeah, it may cause a problem for a first, second, or third class, or it may require some inquiry, basic med is an appropriate step. Now, I will say, and I will caveat this for especially for the flight instructor audience, 61.53 is a relevant regulation that says, if you know or have, I'm paraphrasing, if you know or have reason to know of a medical deficiency, or if you're taking a disqualifying medication, you should self-ground. And so that's always going to be there, whether you're flying first, second, third class, or you're flying on basic med, or if you're a sport pilot. it's still going to be a consideration the individual should take into should take into advisement, and they should always do this self-assessment. And so I wouldn't say it's a total out getting to basic med or going to a sport pilot, because you still have to
Right.
make this caveat. So that's something to keep in mind.
Right, yeah, fair point. Yeah, 6153 is out there and applies no matter what medical certification program you're on or not. In the case of
Right.
sport or gliders or things like that.
I wanted to raise one more point on basic med that we see. We had our firm had a booth out at Sun Fun, and a lot of people were last year, and a lot of people were stopping and asking us about basic med, and they were giving us scenarios where, unfortunately for us, it didn't seem like they really met criteria for basic med, because they were giving us examples where, their last medical certificate had been deferred and ultimately denied. And so that just went on to basic med instead. Unfortunately, it doesn't work that way. If your most recent medical certificate has been suspended, denied, or revoked, you don't qualify for basic med. And that's an important thing. That basic med is not there just to kind of go on to when you can't get a first, second, or third class. It has to be attached to a validly issued medical certificate that hadn't been essentially uh, denied or revoked. And that's something that we see get confused quite a bit, especially as to what kind of denial that the airman may have received. And that may get more nuanced than we want to talk about here, but there are certain types of denials that people don't maybe realize that they were technically denied. And that's something to look into before you go to basic med.
Okay, yeah, that's good to know. I personally didn't even know there were different flavors of
Sure.
denial, so to speak. I thought, yeah, denials were, they would have different conditions, but I've heard of
Sure.
ones where like they just medically didn't meet the standard, and other situations where the airmen just declined to provide their records, so they didn't have a basis to establish medical
Yeah,
qualification. So things like that.
right.
And I think we're subtly making a point here that would also be good for flight instructors to impress on their customers, is that the FAA's view on medical issues and that is going to most likely be different than like your primary care physicians. Because I've definitely seen people who have, very maybe mild depression or anxiety, and their personal physician, or, whichever physician is handling that, says, oh yeah, you're well managed, you're good to go, everything is as good as we would want it to be for this. And they'll give you their green stamp and send you out the door, but that's not how the FAA is necessarily going to view any number of these conditions. I've seen everything from cardiac to everything else fall into that bucket. So remember, the FAA is doing regulatory medicine, not necessarily modern medicine, with your physician.
That's right. That's a great point too. We'll see that quite a bit, and that's kind of the world we live in. Not to plug us, well, it is a situation here with the medical certification that it is regulatory based. It gets into this sort of argument as to, what's a lawyer doing in the medical certification realm. And again, I think the thought process is everything is tied back to 14 CFR Part 67. That is the body of regulations that identifies where an individual should go to look for what the criteria is, if you will, for an individual to be found medically qualified. And so it's sort of an application of fact to law, right? So here's my clinical evidence, and I'm going to apply it to this regulation, and the FAA is going to determine whether or not they think it meets their criteria. And that is an age-old struggle that we see, where the clinicians will identify, hey, listen, our standard is X, and we're treating you to our standard and from a clinical standpoint, but that's different than what the FAA is looking for, because the FAA is trying to mitigate risk. They're not trying to treat the patient, and what may be acceptable from a clinical standpoint, it's not always acceptable from a regulatory standpoint, which I understand, and that's because of the regulations. And so trying to identify for your clinical providers, what the nuances of the regulation and how we're trying to establish that not only are you safe and sound clinically, but you're doing well under the regulation. That is always a struggle. And getting these doctors, it sounds like you're strong arming them, but in some cases, unfortunately, you do have to strong arm them to do things that the FAA wants. So, for example, in certain cardiac perspective, we'll see cases where the FAA will want subsequent catheterization for coronary artery disease cases. And the problem with that is that most doctors say, well, hey, I'm not doing this. That, I run the risk of potentially, having you, like returns, die, while I'm doing this, and I have this liability that you didn't need this. It was contraindicated. There's just really no reason to do this. And the FAA will say, well, hey, well, we want it. And so there's always a struggle there. We see this a lot with substance related cases. The FAA has a very specific understanding of what they think substance dependence is. So if you have nothing better to do, you can look at 14 CFR 67.107, 207, and 307. That's the regulation that speaks to all mental health criteria, but therein the FAA specifically identifies what they think substance abuse and substance dependence means. And that is way different in some capacities than what the DSM-5 identifies to be substance use disorder. And so that is something that we're always plugging and playing with, unfortunately, with the facts, in that we'll have individuals who maybe had a DUI 20 years ago that maybe haven't even drank alcohol since. All of a sudden they have substance dependence because of the circumstances, nuances of the BAC, if they're during the DUI and so on and so forth, because of that regulatory difference. And that's probably where we see the biggest struggle. A lot of people, unfortunately, not being able to get into aviation because of that distinction. Interestingly, I'll share with your listeners that the NTSB has recently released a case, and I'm not sure if it'll go up on appeal, where the NTSB administrative law judge heard this sort of exact situation when it came to substance dependence. The difference between the FAA doctor identifying what they felt the facts were relative to the substance dependence criteria, and a clinical doctor saying, hey, I don't think this is substance dependence. And the NTSB law judge actually said, we disagree with how the FAA is interpreting this and this regulation, and we're going to side more with sort of the clinical look at it. And so that is something that's litigated quite a bit. This regulatory versus clinical sense. And I think that's why it's important for the CFIs and for the students and just about anybody that's in aviation to look at this from a regulatory standpoint, being more, again, not to plug us, but it is, the truth is the legal process, in that we are applying facts to regulation. And I think having eyes on the regulations, not only as a CFI, but as a student, throughout your career in aviation is important, because that's where the FAA lives. If they're going to deny you a medical certificate, they're going to cite a regulation. They're not going to say, hey, we don't like this, we think you're going to die. That's not what it is. It's, hey, you don't meet this criteria. So yeah.
Right. Yep. Two different ball games there. So you kind of brought up the next point. When say someone does face this denial, or things escalate, and how do we end up going from the FAA to the NTSB?
Sure. So that's a good one. So again, being a lawyer, a lot of people sort of suggest that, hey, well, what are lawyers doing here? They shouldn't be involved in the medical certification process. Okay, that's great, but I don't think that is a fair assessment for the airmen, because that's not reality. Like I said, it is a legal process. Now, that being said, not every denial has to go to the NTSB. We're sort of advocates of the idea that, hey, let's try to work it out with, even if you have a denial, let's see if we can work it out with the FAA before this has to go into litigation. And that doesn't mean if you got a lawyer involved, early on in the process, and you're going through the process, doesn't mean the FAA is going to get their lawyers involved. You'll never see a lawyer on the FAA side of things until you get to the NTSB. And like I said, there's a lot that could be worked out with the FAA before you get to that point. So let's say you get denied, you just need to figure out what the FAA's concern is, and then say, okay, well, we understand your concern with X, Y, and Z. Here's medical evidence to support that, maybe I am okay, or I'm eligible for a special issuance, and so on and so forth. So there's a lot that can be done before you get to the NTSB. Asking for reconsideration, even if you've been denied, you can ask for reconsideration, essentially until you're blue in the face. But there are some cases and that where going to the NTSB is appropriate, and those are primarily in cases where the FAA has just got it plainly wrong. The thought process for a lot of folks is that I've got to take every denial to the NTSB. On paper, yes, and I wouldn't blow through any appeal deadline, so I'm not advocating for that. But if it gets to a point where the FAA is just smackly disagreeing with you and your medical professionals, and you put good evidence into the file, and that the evidence supports your eligibility under the regulation, and the FAA is denying you, and it's wrong, going to the NTSB at that point is potentially viable. And the way that works is it's like a regular court case, like one might see a Law and Order, for example. You go in front of a judge. There's no jury there, but you do go in front of a judge, and there's two sides, and you have it out, and the judge, administrative law judge, is the trier of fact. Not ethically, I can't disparage the tribunal, the NTSB, and so I won't. But I will say that the case law, put it that way, has not been favorable to airmen going to the NTSB historically. It has been something that's been largely discouraged, I think, in the community as being a waste of time and tough to beat the government, if you will. And I was one that was right there with them, chanting that tune. And going to the NTSB is not necessarily a good use of somebody's time. But I will say that things seem to be getting better. It's quite a bit better. The NTSB does have new administrative law judges for the most part. I think for the most part, we're seeing very fair decisions come down, and I trust that these decisions there are being thoroughly considered, and the evidence being thoroughly considered. And we are seeing recently decisions that have come out in favor of the airmen, including this case I just referenced, where we've seen medical denials overturned. So it's something that is promising and hopeful, which something we didn't have previously with the NTSB process per se. So we're very hopeful that trend will continue. But again, I have to encourage folks that just because you've been denied doesn't mean that you have to go to the NTSB in every case. Lots of times, excuse me, I would say lots of times, and probably 80% of our practice would be with individuals just asking for reconsideration on a denial. Because again, with the FAA, it's kind of garbage in, garbage out. If you submit bad evidence, if you will, that doesn't help the FAA get to a yes, they're not going to get to a yes. But if you can show them, hey, I really am okay, and here's why, and it's credible, legitimate, honest evidence, the FAA will usually get there with you. In some cases, most cases, let me put it that way. Not every case is going to get there. There are some cases where it's just not going to work.
Right. Yeah.
But,
You do still have
part.
to be medically fit at the end of the day.
Yeah, that's a good way to say it.
And all right, so that's great information for CFIs and helping their applicants understand the process, kind of pitfalls for CFIs, those keywords. Let's say now we are a CFI who's been in the CFI game for a while, and now maybe we're looking to make a professional change and looking at some heavy metal. So someone, and I do see, flight instructors and online and that who, they're moving into it as their second career. Maybe they got their flight instructor certificate, quite a while ago. They were doing it part-time on the side, pursuing their primary career in whatever field, and now want to make it change to the professional aviation. So maybe their first time potentially getting a second or first class medical, because you feasibly could go all the way through flight instructor and have a flight instruction career on a third class.
Sure. Yep, absolutely. So you can even flight instructor on basic med in some cases. So as we mentioned early on in the podcast here, encouraging the student or customer to start early is important. I would encourage the flight instructors to start early with their medical certificate before they start with their applications. I think knowing that they're going to undoubtedly be found eligible to hold a medical certificate, and they can go into their applications, go into their new job, presumably with assurance that, hey, I'm going to hold a medical certificate, barring any unforeseen circumstances. I think that is a good approach to the process. It's sort of obvious, but we do see cases where, excuse me, we do see cases where individuals will unfortunately wait until they've been hired and they have to start class day next week, and then there's a medical certificate problem, and then they're scrambling. They lose their class date. They potentially lose their job if they've been hired and they're in the probationary period. It's always a pucker with those cases, and we see them quite a bit, unfortunately, because it all seems to happen at once. But I think knowing well before you start your application that, hey, I need to make sure my medical is crystal clear, no problems, that's good. And so let's say, for example, we spoke earlier about somebody omitting something from the medical application. They realize, oh shoot, I didn't report my DUI on my medical application. I made it to this point in life as a CFI, and I still haven't reported my CFI, but you don't want it to catch up with you in the application process, or once you've started this career. There are processes where you can amend your medical application to reflect certain history, so as to prevent, hopefully, or mitigate the risk for potential falsification concern. And so we always encourage folks to think, well, is there something I need to amend my application for, so I'm being 100% forthcoming with the FAA, so that I can make sure that I don't have any skeletons in the closet. And there are ways to do that in which you can prevent the falsification, or at least mitigate those concerns significantly. And I have found, like I said, kudos to the FAA, because I have found that for the most part, individuals that do these amendments, they do it correctly. There's a good deal of forgiveness, if you will, from the FAA. There's not a specific policy on it. I'll be blunt. The FAA doesn't have, you're not going to go find a piece of paper at the FAA saying, hey, yeah, you go and amend your applications. My perspective is that they don't want to put that out there for fear that people will start pencil whipping their applications and to say, I'll fix it later. But in practice, we know that this is something that they have graciously considered. So I think the takeaway here, short of my rambling, is to start early before you want to apply for jobs, because that's really going to help prevent those pucker moments.
Right. And if you do have to report any of those conditions that we've talked about, where you may need to get, an assessment or provide documentation, make sure you're getting that information from a reputable source. Like it always, elevates my blood pressure a little bit when I, open up Facebook and there's someone like, oh, I've got a question about this and this on my medical application. And then you look at the comments and they're all over, like, no, this is above Facebook's pay grade. And you need, and it's not like, something simple, like eyeglasses or things like that are pretty generally, routine. As long as you can meet the standard, you're good to go. But they can be pretty medically complex situations, or I've even seen where people have made comments that, oh, you don't need to report that, or you can just ignore that because it's minor, or it's cosmetic, or it's this or that. And it's like, no, if it fits any of that criteria on that form, they want to see it. And I recently had to have a very, very minor dental thing done, and my dentist looked at me like I had three heads, or because I'm like, I'm gonna need to know like all the medical terms for this because I have to report this to the FAA.
That's fair. Yeah.
And
it gets that minute for sure. And you get looked at cross-eyed by doctors and whatnot, say, hey, I need to know what the diagnosis is on this pimple here, but it happens. And so,
that's not too far removed
right
from what it was. A completely benign situation, and I'm like, I need to know like what the word for this thing is, because I've got to tell the and they're like, they want this level. I'm like, yes, they do. And on top of that, I need to report when I came in for the consultation, the medical visits, like the pre-op, the op, the post-op, I'm like, every single one of those.
That's the thing, the people telling you not to put stuff down, and this sounds like fear mongering, and I'm not trying to do that. But I mean, those people are going to be long gone by the time if the FAA were to catch up with you that hey, you didn't put this down. Those people are not going to be able to come in and testify, say, "Hey, I told them not to put it down." So they're useless at that point.
Right.
So you're absolutely right.
Yeah, go to those credible
Yeah,
sources, whether it's a professional, medical certification group or AOPA has a lot of great resources online. There may be other associations that do. So at
sure.
least start with a reputable source that's not Facebook and or
Yeah.
your preferred social media platform, and talk to
Yeah.
someone who knows, really knows this inside and out, because you can get in trouble,
Yeah.
and the FAA isn't going to be impressed if you say, oh, I didn't have to report that because Facebook said it was cosmetic. I'm like, well.
Yep, absolutely. You're right. And there are a lot of great folks out there. There are other law firms that do it. There are medical certification services. It's like Wingman Med. There's Pilot Medical Solutions. A lot of good folks.
Mhm.
So I
Unions
definitely
and things like that may
I'm
have resources.
yep. There's AMAS. Yeah, there are a lot of good folks, and so and I'm not here to say, oh, you got to work with us. I just want folks to get what they need. And I think it's such an important thing because I've just seen it, unfortunately, ruin careers and when it didn't have to. So
Hmm.
I think getting that advice and making sure that whether you're CFI a student or you're an astronaut or whatever, you need to make sure you're informing yourself because it's something that can trip you up easily, but it's also something that can be fixed for the most part pretty easily too.
And one thing, just to kind of tag on something here at the end, I always encourage my students, and this is a practice I do myself, when I fill out basic med online and I click the submit button, it gives you the option to print or download your application. And so make sure you're
Mhm.
doing that, because you're not going to be able to get back in and get it back. And so I have a little folder on my
Sure.
computer that's my medical applications, and when I have to fill it out again, I open up that last one, and if you have to have a little attachment sheet of your, because they only give you very few spaces for your doctor's appointments for the last 3 years,
Right.
which
Right. Right.
if you're, even just the annual checkups and the annual dermatologist and the dentist, and it's not hard to fill that up just with kind of your routine
Sure.
screenings, and
Absolutely.
have all that right there, and make sure it's super consistent from year to year. It's definitely in your interest to keep those records. I've
That's a
personally found it
great
very hard to
idea.
extract it out of basic med, and so I just have my little folder. And
Right, you're right. That is perfect. And I encourage people to do that. That's a great thought, Sarah, because some people don't know what they've said, especially if you're like a third class holder and it's 5 years and you're under 40, and it's 5 years in between applications. I don't know what I said on 18X last time, or if I said yes to 18X last time, which so having those it's easy because otherwise the only way you can get that only way you can get your medical application, unless your AME is kept a copy, which is not common, you have to do a Freedom of Information Act request for your airman medical file from the FAA. And right now we're seeing that we ask for that on every client just for good measure. And that's taking about 4 months in
oh
some
wow.
cases, most cases, just to get that. So keeping that is critical. And even if it's a picture you take on your phone at the end, after you complete the Med Express, I think that's good. That's good advice.
Yeah, so hang on to your own records for your own sake, and
Right.
that's what I do, and encourage others to do. And I think that pretty much wraps up what we had to talk about
Yeah.
today, and give flight instructors a good high level overview of conditions they really should be aware of in their students, but not be helping them out themselves, and
Right. Absolutely.
and things to look out for their own as well. So thank you, Anthony, for
Sure.
taking the time to be here with us today. We're thrilled you were here to offer these insights.
Thank you so much, Sarah. I appreciate being here.